Now, let me introduce our speakers for the third session, who will give a speech on constitutionality of eviction policy. Right.
You feel so Men in Black. Good afternoon, everyone. Okay. Well, you guys have already had the food, so there's no excuse. So we wanted to start with a brief exercise. So first, we wanted to ask everyone to close your eyes. Imagine you live in public housing. You're walking home, and the police stop you because you resemble a robbery suspect. You're then arrested, and you learn that it will take months to resolve your criminal case. Nevertheless, 2 weeks after your arrest, you receive a termination notice stating that the housing authority seeks to evict you because you engage in criminal activity. You say to yourself, wait a minute, this is a mix-up. I'm not even the person who committed the robbery. I have no idea what's going on. I haven't even been convicted yet. Can I really lose my affordable apartment? Open your eyes. The reality is yes. There are 2 federal regulations that authorize public housing authorities across the nation to evict tenants, subsidized housing tenants, if they find that they have been engaged in criminal activity. What that essentially amounts to is that these public housing authorities do not have to wait until this tenant has been convicted of a crime. In fact, the wording of the regulations are so broad that they don't even have to rely on an arrest. It's just that if you suspect that a person has engaged in criminal activity. So theoretically, if I have a neighbor and my neighbor says, I think I saw Jane Doe smoking marijuana, and they report Jane Doe to the housing authority theoretically could start an eviction case because they could say that Jane Doe engaged in criminal activity upon the word of a witness. That's how broad the federal regulations are. And we're here today to talk about whether these 2 federal regulations are even constitutional. So we wanted to first give a brief interlude into what is public housing, and specifically what is subsidized housing. I feel like you should be standing next to me, actually. Okay. This is my partner in crime. So Helen and I actually, we work together at the Urban Justice Center. I'm currently at MFY Legal Services, one of the supervising attorneys. While at Urban Justice Center, just to give a little bit more background into our work, I did some housing work as a staff attorney, and we represented tenants, mostly in public housing, who had non-payment cases, who, of course, were being taken to court for non-payment, but also there were different types of cases. So, for example, if you were accused of breaching a clause in your lease, the lease says you can't have a cat, you have a cat, we're going to evict you over that. Those are types of cases that we took. And also, as Ms. Webb described, we had a lot of cases where tenants had repairs. They had a lot of conditions that really required, unfortunately, them to take the next step and take the landlord to court. And so we work a lot. Our line of work is what people refer to as poverty law. And honestly, we do this work because there's a lot of the folks that we represent, they really need strong representation. We were actually just discussing last night the fact that a lot of times when people hear the term public housing or subsidized housing, it's such a hot button term because there's just a lot of controversy around it. People automatically think of these ideas about pull yourself up from the bootstraps, people who don't have jobs, but they don't typically think about people who work who are the working poor who need a place to live. So for example, in New York City, it might be $1,200 for a studio in Bed-Stuy, but if you make $35,000 and you have a child or two, it's really hard to pay $1,200 for a studio. And there's not much middle ground, which is a conversation that the nation's having. So a lot of people end up having to apply for public assistance. And as Helen can speak to, she actually wrote an amazing report. It's time to shout out my colleague. She actually wrote this amazing report where people would go in, apply for public assistance or try to apply for public assistance in these centers, and they would have to wait 4 or 5 hours only to be told, come back, or they would be given a sheet of paper and say, you know, you never submitted this documentation, your application is rejected. And Helen can speak, actually, it's her report, and it was quoted in the New York Daily News and other news sources, but.
Yeah, so I mean, it sort of speaks to a point that we'll talk about in our presentation as a whole, which is the hyper-regulation of the poor and people of color. And this happens in public assistance offices, the same that it happens in public housing developments, unfortunately, across the nation. And you know, we're going to be really delving into one aspect of this hyper-regulation and criminalization also of poor people and people of color, which is in public housing developments across the country.
So just to clarify, you know, Natalie had touched on it, but a lot of times when people hear the term Section 8, they think of Section 8 project, and then they think of projects like buildings. So when we say public housing, we mean property that is owned and operated by typically a city government, so typically a city public housing authority. And Section 8 tends to be portable vouchers, that it's literally a portable voucher, and a local agency pays for, if you take this portable voucher to any landlord, a local agency pays for a large portion of your rent, and then you also chip in and pay for a portion of the rent. So Section 8, there are also a third type of housing called project-based Section 8, but generally just think about it as public housing are colloquially known as projects, and Section 8 with the vouchers are typically portable vouchers that people can take to any landlord. So the two federal regulations that we're addressing today actually apply to both Section 8 recipients and tenants who live in public housing. And Helen's going to talk now a bit about the history of what we call one-strike evictions.
Great. I'm realizing I forgot part of my presentation. Okay, great. So I just want to talk by talking about the history of this policy that Leah gave you an example of in her opening, that's known as a one-strike eviction. So legislatively, it was part of the 1988 Anti-Drug Act, which was a large omnibus bill passed by Congress as part of the war on drugs. And this bill had a lot of components, but one component was this provision about public housing residents. And it stated that a public housing resident could be evicted for any suspected criminal activity that they had committed, that any member of their household had committed, or even a guest of theirs had committed. So this is part of the 1988 Anti-Drug Act as part of the war on drugs that was in full swing in this country at that time. So that's where it first becomes law. However, the prevalence of one-strike evictions really ramps up starting in 1996 under the presidency of Bill Clinton. And in 1996, in his State of the Union, Bill Clinton announced that they're going to start vigorously pursuing one-strike evictions across the country against public housing tenants. And I'll just quote him from his State of the Union. From now on, the rule for residents who commit crime and peddle drugs should be one strike and you're out. And that's where the name one strike comes from that State of the Union speech. And the interesting thing is, you know, when he announces the policy, when he speaks about the policies, he says it's going to be the rule for residents who commit crime. Well, how do you define commit a crime? We have a definition that we've developed in our criminal justice system, which includes all the standards you're aware of, the right to counsel, beyond a reasonable doubt, the various protections that people are afforded, although we know that they're very imperfect, but they are some measure of protection that are not afforded in civil proceedings. So 3 months after the State of the Union, the federal government, the U.S. Department of Housing and Urban Development, HUD, which is the agency that oversees all of the public housing authorities all over the country, releases its official guidance. And I'm just going to read you an excerpt from their guidance where they talk about what does it mean to determine that someone has committed a crime. In order to terminate a lease and evict a tenant, a criminal conviction or arrest is not necessary, and public housing authorities need not meet the criminal standard of proof beyond a reasonable doubt in eviction proceedings. Public housing authorities should specify in their leases that criminal activity is cause for eviction even in the absence of conviction or arrest. Any provisions in state laws that require conviction in order to evict tenants are preempted by federal law. So making it very clear, you don't need a conviction, and certainly you don't even need an arrest to pursue an eviction against a tenant for suspected criminal activity. And Leah will go into this more later, but you're setting up a situation where folks can now face eviction based on hearsay testimony in a hearing where they don't have access to counsel, in a hearing where the standard of evidence, the burden of proof is extremely low. And because of what Leah talked about in terms of public housing really being perhaps for a lot of folks the only affordable housing option in the city that they live in the city that they may be from, then facing homelessness. A lot of folks that live in public housing maybe they're all paying around 30% of their income, and so depending on that income it could be a rent that's somewhere around $500, $600. It all depends on the tenant. Compare that with what you need to pay to rent a 2 or 3 bedroom in New York City, a comparable apartment, you're talking like $2,000, $2,500, and that is not something that a lot of people can afford. So it's really, the stakes are extremely high in these hearings. Even though they are civil procedure, you're talking about someone going from, having stability and having a home to homelessness in many cases. So the other thing that happens when Clinton decides to put this policy into place in 1996 is he decides to attach a funding component to the housing authorities and how they're carrying this out. So housing authorities are now going to have to report to the federal government, to HUD, how many of these evictions they're carrying out, what are the different procedures they've put in place to make sure these evictions are being carried out, and the funding for the housing authority is going to be tied to those reports. So housing authorities that say, you know what, we don't really think we want to pursue these evictions that aggressively could face loss in funding from the federal government. So a really strong incentive structure put in place for this to be pursued. So that happens. So now I want to talk about what's the impact. How does this start to play out across the country? So unfortunately, there aren't a ton of national statistics. We don't know exactly how many one-strike evictions happened each year because HUD doesn't publish that data. But we do have some limited data from different housing authorities across the country and a little bit of national data. So we know that in the first 6 months that from when one strike was evicted, evictions went from 9,000 a year to 19,000 a year. Okay, that's a quite significant increase, and that's just in the first 6 months of implementation, so it hadn't really been ramped up and developed in a lot of the public housing authorities across the country. We also have some statistics from specific cities. So there's an interesting study about one-strike evictions in Chicago from August of 2000 until April of 2002. During that time period, 717 one-strike cases were concluded, were brought to termination, and there were an additional 847 pending cases that were brought during that time. And when I give out those numbers, that's not 717 people, it's 717 families, right? That's 847 families, because each case can potentially mean the eviction of the entire family. We also have some interesting data on the outcome of those cases. So in the 717 cases that were concluded in Chicago, in 46% of the cases, the whole family was evicted. And in an additional 37% of the cases, at least one family member was evicted from the household. So I think that leaves around 18%, a pretty low success rate for folks facing these evictions and facing these eviction proceedings. And here I want to talk about the difference between the whole family being evicted versus one individual being evicted, because those are two potential outcomes of this case. So federal statute basically gives the housing authority the discretion to evict the entire family based on the action of one household member or any guest of any household member. So the housing authority can choose to pursue the eviction of the entire family. They also have the discretion to pursue the eviction of the individual who is alleged to have committed the criminal activity, and that's commonly known as permanent exclusion. So I'll give you an example of what permanent exclusion looks like and permanent exclusion, how it plays out, because it's something that we see a lot in New York, and a lot of tenants have gone through this process and have had family members who have been permanently excluded. So what that looks like is, let's say,
what it looks like is basically grandma lives in a NYCHA apartment. NYCHA, again, is a New York City housing authority. And her grandson engages in some type of criminal activity. And let's say it's possession of marijuana. And the housing authority says to grandma, well, we know that you were not arrested, and nor were you convicted or you were involved in any type of criminal activity, drug-related, but we can evict you and grandson as opposed to just evicting grandson. However, if you don't want to get evicted, your last shot is you can sign an agreement saying that your grandson can never visit you again. He has to leave, and he's permanently excluded from the entire premises of the development. So if we see him here 10 years from now in the parking lot, if we see him downstairs in the lobby, if we catch him in your apartment, then you will be evicted. So this agreement is your last shot. So you can stay here. However, what you're signing is saying that your grandson can never be on the premises. And even if he is on the premises one day and you're not aware of it, you can still be evicted. So that's how permanent exclusion operates. A lot of people sign these agreements and they're not really sure. They don't have an attorney and they don't understand that it's permanent. So I've seen personally some cases where a mother is on the phone with her son who has been permanently excluded for 10 years or so, and she's on the phone and she says, oh my God, I think I'm having a stroke. He runs over there because his mother tells him she's sick, she's having a stroke on the phone, and he takes her to the hospital. NYCHA learns that he was there, and they started an eviction proceeding against his mother because her son, who had been permanently excluded, she violated that agreement because her son came over. So some of these stories are really draconian, really harsh, because the person, again, doesn't know what they're signing, and the implications don't really allow for any type of rehabilitation for people who have been involved in the criminal justice system, and even for families who would like to stay together. So.
Yeah, and it sounds kind of crazy, but they have inspectors and they'll send them like on birthdays of family members to see whether the family member's there. They'll send them on Christmas, on Thanksgiving, on holidays, because they're like, oh, this is the time when maybe the family member will be there, which sounds, when I learned that, I thought that sounded completely crazy, but it happens, and it's part of what we're going to be talking about, which is this hyper-regulation of people's lives and honestly criminalization of people's day-to-day activities.
They actually enter into with the apartments and, like, no kidding, they like open up closet doors, like no one's in here. Like, it's really rigorous. It's when we say hyper-regulation, we mean hyper-regulation.
And this is the price that folks, unfortunately, have to pay for living in this particular type of subsidized housing. I'll just note that there's a lot of different types of subsidized housing in this country, including homeownership is actually quite generously subsidized by the federal government through the mortgage interest deduction. But yet homeowners are not subject to these sorts of searches, this sort of regulation. But we've decided that this sort of subsidized housing can be subject to those sorts of hyper-regulation of people's activities. So just to give you some context. The other statistics I wanted to go through is a sense of, so when these one-strike evictions are being carried out, what sort of charges are they for? There is some data in Chicago from 2005 to 2010 that showed that 28% of one-strike evictions were initiated for marijuana possession, out of an overall 73%, which were for drug possession charges. So folks who are going to face homelessness for marijuana possession or drug possession. Only 4% of one-strike evictions were initiated for weapons and 8% for drug sales. So it just, when these policies were put out there, they were put out as things that we have to do to ensure the safety of public housing. But the statistics really make you question how closely these things are related to outcomes that will lead to more safety for residents. So I also want to talk a little bit about some of the perverse financial incentives, unfortunately, that have existed for public housing authorities to aggressively implement one strike. So as Natalie talked about earlier, during the 90s, and during the 2000s as well, a lot of public housing across the country was torn down because it was deemed to have been a failure, and it doesn't work, and we're going to tear it down. So what happens to the folks who are living in the public housing developments when they decide to tear it down? Well, so the cities actually have an obligation to relocate those folks to some other form of affordable housing. And a lot of times that's in the form of giving them some sort of voucher, maybe a Section 8 voucher, or relocating them. But if someone has been evicted from public housing, then you no longer have a responsibility to provide them with the voucher and to pay for them to be relocated. So there were unfortunately a bunch of cities where it was documented that one strike was being used as a tool to reduce the city's financial obligation in terms of relocation and vouchers. So this happened in Chicago. There was also an interesting study in Atlanta from 2000 showing that the Atlanta Housing Authority made a deliberate attempt to empty out residents as it was being required to relocate them. And also there were a lot of activists in Tampa and St. Petersburg who documented how there was this huge spike in evictions at the same time that the housing authority was being required to pay relocation fees and pay for vouchers for folks. So this perverse financial incentive unfortunately existed as well. The last element of one strike that I want to talk about before I hand it over to Leah, who's going to talk more about the legal elements of this, is that one strike leads to really unprecedented coordination between law enforcement and public housing authorities across the country. So part of making this process work is setting up a really close relationship with law enforcement. And what does that mean? That means that in a lot of places, as soon as an arrest is made, the police department directly shares that information with the housing authority. An eviction proceeding can start, 1 or 2 weeks later, very quickly following the arrest.
And they know by the person's address that they live in public housing, so that's why they share it.
Right. And the other element of this is increased enforcement. Part of one strike was increased enforcement on public housing properties. So because this relationship had been developed, the housing authority were asking the police to step up enforcement, which could be a good thing, but in the case of how this was carried out in many public housing developments, it was in some ways it violated residents' constitutional rights, and it was extremely extreme. So there's a sociologist, Louis Wacant, who coined the term the prisonization of public housing. And what he describes with that is how during this time period, public housing complexes in many areas came to resemble jails and also served as systems by which residents were sent to jail. So some of the systems that were implemented on a lot of public housing developments included curfews, right? Like, okay, and I now have a curfew for my apartment. Video surveillance, illegal searches on police, unfortunately, became very common on a lot of the grounds of a lot of public housing developments. Barbed wire fences, right? Also very common. Restricted access for visitors, so you can't have whoever you want to come over to your apartment. There's some sort of screening process for that. And in one development in Chicago, it even got so extreme as to get into the development, you had to go through a metal detector and a pat-down to go to your home, to go to your apartment. So, when I say those things, you really see how it resembles more of a prison system than a home where someone might live. So one strike really, and when I say these things, it's not going to be the same at every public housing development across the country because public housing looks very different in different cities across the country. And certainly not all developments, right, had barbed wire fences, had metal detectors, had pat-downs, but the one strike policy did lead to this increased coordination, which means that in many cities, some of these features did start to be put in place. So at this point, I'll turn it over to Leah, who'll talk about the legal elements of the process.
So one of the things that we looked at was how we can attack these two federal regulations that were pretty clear. So the federal regulations cite two main points. One is that the person being suspected of criminal activity doesn't have to be arrested or even convicted of a crime. And the second part of both of these regulations cite that the evidence used against a person once they're facing some sort of litigation, like an eviction proceeding, which is civil, or a criminal, well, actually not the criminal proceeding, just the civil eviction proceeding, that the evidence used can only be preponderance of the evidence. And that is a very low standard. The preponderance of the evidence standard literally is, I have evidence before me. I think strikes right. Like, I think about 51% of this feels good. I think the person is committed this conduct. As opposed to, for example, reasonable doubt, where literally, if you're going to make a determination that someone engaged in some type of conduct, you have to be sure beyond, quote unquote, a reasonable doubt that they in fact engaged in certain conduct before you, as you're making the determination. So by having this very low preponderance of the evidence standard, that factors into a lot of the conversation because, again, you don't have to wait for a conviction. You can typically have someone who has been arrested and you have a civil proceeding against a person, a civil eviction proceeding. You have the arrest record and you just say, yep, there's an arrest record here by the New York Police Department that you were arrested for robbery. This is it. This is the arrest record, so you engaged in criminal activity. That's it. They might even ask a couple of questions of the tenant, but some of the things that we're looking at and that we found were really interesting. And I just want to note that we looked into this legal part, and no one's written about this part. What's been written about, there was a case called Rucker in 2002, decided by the U.S. Supreme Court, which goes back to what Helen was talking about. It was a case of a grandmother who she lived in, an elderly lady, I'm not sure if she was a grandmother, but she lived in a public housing development, and her aide, her home health aide, was arrested on a drug charge. And because of that, she was faced with eviction proceedings because an occupant, a guest, or whoever in her house was arrested on a drug charge. And so the question there was, can I be evicted because of the conduct of someone else? So one of the issues there was really related to this sort of like idea of third party, like can I be evicted for the conduct of someone else? And here, what our issue is that we found that we really wanted to zoom in on is, can I be evicted when I haven't even been convicted of the crime? So for some people, they may not even have been arrested of the crime. So what happens is, a lot of times, a criminal case, especially in New York, there was huge coverage of this in the New York Times. Criminal cases drag on for a very long time, especially in certain counties like the Bronx. So I don't know if you've heard of the name Khalif Browder. He was in, I think, Rikers for a year for a crime that he didn't commit. He ended up committing suicide, but his case received a lot of attention because it really showed how long the criminal justice process takes in certain states, and especially for people who haven't even committed the crime, but how long it can take to be cleared of it. So thinking of that as a backdrop, imagine that you've been arrested of a crime, your criminal case is dragging on for a long time, you're innocent, but it takes a long time to prove that because your criminal case is dragging on. Meanwhile, your landlord speedily starts up a civil eviction case against you. So some of the things that we looked at were what happens there. You have some type of civil proceeding. It can be an administrative proceeding, which typically is preceded by a civil court eviction holdover, what we call holdover proceeding in civil court. But some of the issues that we looked at were, well, what happens there? You don't have a right to counsel. So like in a criminal case where you're indigent and you cannot afford an attorney, and an attorney may be provided for you. That is not the same in a civil eviction case. So you're there typically by yourself, particularly if you're poor, and most of the time, almost all the time, if you live in subsidized housing, you live there because you're low income. So you're low income, you are without an attorney, and typically you're making statements on the record in this civil proceeding. So, the housing authority typically has their own witnesses. They might be housing managers, housing assistants, and they'll say, this person's been a troublemaker, I saw this person, et cetera, et cetera. And then the housing authority has their own attorneys, and they'll ask the tenants, is this the arrest record, what happened there? And people will just talk and talk, and they might not be aware of their legal rights. So one of the issues that we found is that people are in these civil proceedings without an attorney, freely talking, so forth. And if you invoke, per se, the Fifth Amendment, like I don't want to talk about it, well, what happens there? It might not even help you that much, because a lot of times they just say, well, here's the arrest record. You don't have anything to say, okay, but here's the arrest record, that's it. We're going to vote to terminate your tenancy. So one of the issues we found was how the lack of the right to counsel plays into these situations. Another issue that we looked at was the very low evidentiary burden. So, for example, obviously in criminal proceedings, when you have beyond let's say, for example, we had incorporated the evidentiary standard of beyond a reasonable doubt in these proceedings. Well, if you just had an arrest record and the evidentiary threshold was beyond a reasonable doubt, I'm not sure, I don't think that would pass the bucket. You would have to show that they engage in criminal activity, and an arrest record is probably not going to be enough to prove beyond a reasonable doubt that they engaged in criminal activity. So elevating the evidentiary burden is also one of the recommendations that we had, specifically elevating the evidentiary burden from preponderance of the evidence to a higher standard in these types of eviction proceedings where criminal activity is alleged. So that's one thing that we looked at. And the other thing that we looked at is, just to back up, so backtrack, why should the evidentiary burden be elevated, right? Because there are all types of criminal proceedings. And actually, just to back up before then, there is not, you might say to yourself, well, why can't you get the civil proceeding stayed until the criminal proceeding is resolved? So again, because technically you don't have to wait for a conviction, you don't even have to prove that there was an arrest, a civil court judge, either an administrative law judge or a judge in civil court, doesn't have much incentive to stay a civil eviction proceeding just because the tenant alleges, well, I want to wait until my criminal court proceeding is resolved, because they can say, well, listen, we don't have to wait. We don't even have to see if you were arrested or that you were convicted. That's not what the evidentiary standard is. So we can proceed now. So essentially, the disposition of the criminal case becomes not really material or relevant. So recently, in the last week, there was actually a case published in the New York Law Journal where it was considered a major victory even, that a case was stayed by a civil court, an eviction case was stayed by a civil court judge pending the resolution of a criminal case. And that is in 2016. And that was considered a major victory enough to be published in the Law Journal. So I just want to really emphasize how rare it is. Really, it's not very commonplace to just sort of file a motion and get it stayed, because again, from the public housing authority standpoint, or perhaps the Section 8 landlord standpoint, they're like, I want to get this person out. There's no reason to hold this up. It might be held up for a year or 2 years, however long the criminal case is going to take. And so I want to get this tenant out now. There's no legal standard per se to have, we don't have to prove that they were convicted. We don't have to wait for the resolution. We want the tenant out now. So those are some of the issues that we're facing, the evidentiary burden and also how the right to counsel plays in. The other thing, the other thing that we were looking at is just looking at these sort of parallel proceedings. Again, it doesn't have to be stayed. Now, typically in other types of cases, like let's say there is a sexual assault case, right? And we've seen this with a lot of celebrities. At this point, I don't even have to name any names. There are a little too many, but the criminal case goes on, the criminal case is over, and then after that, there's a civil case, often for damages, for money against the person who's been accused of or possibly convicted of sexual assault after the criminal case, seeking relief. But here, again, it's kind of turned on its head because the civil case often is resolved before the criminal case. And if you're a savvy prosecutor, all of these statements that subsidized housing tenants are making in these civil court proceedings, oh yeah, this happened, but I wasn't sure, and they're saying it into the record, you can use them. Those statements are not privileged in the sense of like you can't use them. You can use those statements. So if the prosecution, it happens to happen after the civil case, everything that was said by the tenant on the record in the proceeding is often used against them. And typically they don't have a lawyer, they don't have witnesses of their own, and they don't have this sort of legal savvy to understand how these proceedings work, so it typically works against them. Just a quick note about the evidentiary standards. One thing that we looked at to back up our arguments is that there are certain types, legally, there are certain types of cases where, there are certain types of cases where the Supreme Court and other courts around the nation have supported elevating the evidentiary burden because the legal right at stake was so important that a low evidentiary burden was really inappropriate. So for example, there have been cases where there's a parental termination case in civil court, and the evidentiary burden was preponderance of the evidence. But the important interest at stake there was the fact that a person's parental rights could be terminated and could be taken away. So some courts found that if the end result is that there's going to be a parental termination, then certainly preponderance of the evidence is too low, and it's actually considered a violation of procedural due process to have an evidentiary standard so low that kind of streamlines a result that's against the person, right? So that's against the parent. The same in, for example, a denaturalization case. The same in other types of fraud cases that deal with, the person is accused of fraud. And some courts, including the Supreme Court, has said that a preponderance of the, since this is sort of a quasi-criminal, like, and specifically with fraud, since this is sort of a quasi-criminal-like case, it's in civil court, the evidentiary standard should be at least clear and convincing evidence and not preponderance of the evidence in order to prove that the person engaged in conduct X, Y, and Z. So we used a lot of those cases, and we're using them in our law review article to support the notion that certainly if someone's losing their housing and they're facing eviction based on criminal activity, that the evidentiary standard shouldn't be as low as, seems like they did it, feels right in my gut, 51%, let's go ahead and terminate their tenancy. Especially because a lot of people who live in subsidized housing, that's pretty much the last bastion of affordable housing. So once they get evicted, a lot of people end up going to a shelter because there's no other, especially in New York City, there's no other form of affordable housing. And rent-regulated apartments, which are another aspect, they're kind of private, they're not public housing, but they're very hard to find. So a lot of people end up entering the shelter system. So that's one thing that we looked at. There are some positive results. So we're specifically talking about people who are already living in public housing, that they're tenants. But there was a case out of Chicago, I think it was at the circuit level, no, it was the Chicago Appellate Court, where someone applied for public housing. A man applied for public housing and the Chicago Housing Authority, and his application was denied because he had been arrested. Now here, the case was interesting because this man had been arrested 9 times, but each of those arrests were dismissed. And he actually provided evidence that he had been homeless. And so the reason why he had been arrested for each of those 9 times is because he was out on the street and there were sort of charges like, oh, you're loitering, you're this. And so he was more out in the open. And so he had been arrested 9 times, but each of those charges had been dismissed. He provided evidence before the case to the Chicago Housing Authority that these charges never stuck. I've never been convicted. There's never been a guilty plea. These charges have all been dismissed. And they said, oh, it doesn't matter. You've been arrested. So obviously he said, well, what does this mean? I'm homeless. I, now was at the end stage of getting possibly affordable housing, and I've been denied because I've been arrested, but those charges haven't stuck. So he started a court case, and actually the Chicago Appellate Court agreed with him and said that you can't use here an arrest, especially when there's proof that the person didn't actually engage in criminal activity. Now, there was also what's called a HUD circular. HUD is the overarching agency, as Helen and Natalie described earlier. It's a shorthand, an acronym for the U.S. Department of Housing and Urban Development. So it's a federal agency. I think it's, what's his name? He was the mayor of Texas. He oversees it. Julian Castro, maybe. I might be mixing up names. There's so many characters right now in our political scene that it's become like a reality show, right? So there was a HUD circular. HUD does issue circulars, and there's sort of like guidance in certain areas. So for example, the EEOC might issue an enforcement guidance on how they feel like certain employers should look at a certain issue. So this HUD circular was published in November 2015, and it specifically addressed arrests, like evictions based on arrests. And it was positive in the sense that the end result was that if you are a public housing authority, you cannot rely on an arrest to terminate a tenancy. However, upon a closer reading of it, that HUD circular specifically is zooming in on the issue of verifiable arrests. So for example, a public housing authority, I used the hypo before, would start a termination proceeding against a tenant, and they would just say, here's the arrest record, your name is on here, Leah Goodridge, that's it. And that would be it. That would be their only evidence. And so this HUD circular doesn't actually go so far as to say you need to wait for the resolution of the case. What it says is you can't use, per se, just the arrest as the only evidence. You can use the arrest and then supplement that evidence, that documentary evidence, with testimony of the police officer who arrested the person, or testimony of someone from the police department to say, this arrest record is valid, and you can use that to terminate the tenancy of the person, but you can't just rely on the arrest record. The reason why is the Shriver Center published a really great report showing that arrest records actually are not reliable by themselves. A lot of the arrest records have wrong names, or there are actually some people who've never been arrested and their names are on arrest records. So that HUD circular really is zooming in on the issue of whether arrests themselves are verifiable. So you can still, if you're a public housing authority, terminate the tenancy and evict a subsidized housing tenant just based on an arrest, so long as you use multiple forms of evidence, like testimony from a police officer who did the arrest, or just testimony from a police officer of the department to say the arrest record is valid, and so forth. But you do not have to wait for the resolution of the criminal case, if there even is a criminal case. as a practicing attorney, I haven't seen scenarios where a person has been, not that they don't exist, but that a person is facing eviction based off of hearsay of a neighbor and that there hasn't been any kind of arrest. But I've definitely seen scenarios where a person has been arrested, their criminal case is lagging on, and they come to our office and they're like, we never did this, we have no idea, we were just, you know, sitting on the bench and they just arrested us and that's it, and now we're facing eviction. And the eviction case actually speeds on. Now, there was actually a recent initiative by our mayor, Mayor de Blasio, to speed up the eviction proceedings. So right now, the way it works is, let's say Helen is the NYPD and I am the Public Housing Authority, and Helen has a recent arrest record of Jane Doe, who lives in Carver Houses, which is a public housing authority. As soon as Helen sees that address, she forwards it to me, the Public Housing Authority, like, hey, heads up, someone in your development has been arrested. And then, as soon as I get that, as a Public Housing Authority, I'll start the eviction proceeding. Now, typically, this has sort of not been the quickest. It might be 4 weeks, a couple of months after receiving the records, but the New York City Mayor, Mayor de Blasio, has proposed an initiative to speed up the process to 2 weeks after the person has been arrested to start the eviction proceedings. So, you know, obviously a lot of tenants who are in these situations, they have a criminal case lagging, which they cannot, it's out of their control, they can't control. And then they're facing the possibility of losing their very affordable apartment, possibly over conduct that they didn't do. Now, you might ask, well, what happens if they lose their apartment and then they're later cleared of the charges? That's it. They can't get back their apartment. The Public Housing Authority is just going to say, look at this federal regulation. We didn't have to wait until there was a criminal conviction. That's it. It's valid, period. So those are some of the issues that we came up in terms of, that we looked at in terms of procedural due process. And really quickly, I've been using the term termination of tenancy. So in a lot of public housing, they have policies where before you actually start the eviction case itself in civil court, if it's based on certain types of activity, there has to be an actual administrative proceeding first. And that's done, you know, with an administrative law judge. So it's a little different than being in civil court. However, in our experience, so first off, civil court has different evidentiary rules and very different sort of proceedings than criminal court. So a lot of things like hearsay and admission of certain types of evidence, it's a bit more lax. So civil court itself is generally more liberal in terms of what can be admitted and so forth in terms of evidence than criminal court. And then on top of that, administrative proceedings are way more liberal than even civil court. So and the other thing is a lot of times in my experience, a lot of the administrative law judges in the administrative proceedings are pretty much, they're pretty much like on the side of the agency already, because they see these proceedings all the time, they practically work there, and so that can be very challenging. So one of the things that we looked at was what difference it made if the eviction process started with the termination of tenancy proceeding that's an administrative proceeding, as opposed to just going straight to civil court, where typically a housing court judge is a little bit more neutral than an administrative law judge. They sort of have to be, a lot of them are appointed or elected. So it's a little bit more protection, at least in my experience, than the administrative proceeding. So when you have it, there's no sort of like double bite at the cookie. You have an administrative proceeding, your tenancy is terminated, then you have an eviction, at least in New York, then you have, as soon as your termination is terminated, your tenancy is terminated, you have a holdover in eviction, in civil court just to evict you because your tenancy has been terminated, and that's it. There's typically no trial. It's just sort of like, okay, your tenancy was terminated already in the administrative proceeding. This is just a formality to go ahead and evict you with the marshal. So those are some of the things we looked at with the procedural aspect. And just to sum up that part, we looked at the dynamics of the actual eviction proceedings, like the right to counsel and things that they say being held against them, like how the effect of not having counsel in these civil eviction proceedings ultimately affects the tenant. And we also spoke about the evidentiary burden. So quickly, I'm going to talk about, we have started looking at how this might all play into ultimately a racially disparate impact, right? So if you live in public housing and you are a person of color and you are arrested based off of racial profiling, so people of color are disproportionately arrested because they're people of color, and then as a result of you being arrested, you are evicted on the basis of your arrest. Helen and I were certainly looking at whether this qualifies as a violation of the Fair Housing Act. There's also the Equal Protection Clause, but I think that's a little harder to make the claim. There's been, Charles Lawrence wrote a really great law review article on like the ego and sort of like looking at when you're trying to make a disparate impact claim and whether you have to prove intent and motive, because I think, and certainly we've seen that a lot of times when you bring up racism, the main question that people ask is, well, did the person mean it, right? And did they have intent behind it? Because, if Charles said that Joan looks like a monkey, but he didn't really mean it, that like really mean the intent of his words, like whether it was racist or not, really matters. So in a lot of ways, that's how civil rights litigation has played out, of whether if the person didn't have the intent in their heart, then the effect, or maybe there wasn't any racism. However, a lot of the litigation regarding disparate impact goes to, we don't care about intent. The ultimate result is that, a certain group, protected class, is being disproportionately impacted. So who cares if Charles or whoever meant to do this? Who cares if the police department meant to purposely not have police officers of color pass a test? Who cares? The impact and the end result is that, 90% of people of color who take a certain test fail. So that's the anatomy of disparate impact. And we were looking at, and we're still doing some research on this because we need statistics for different housing developments, but we were looking at how our arguments, and we're still looking at how our arguments could fit into whether the end result of tenants being evicted based on an arrest, which the arrest itself is unlawful because of either racial profiling or stop and frisk, based on the person's ethnicity or race. We're looking at whether that results in a racially disparate impact. And just a quick note, LDEF, which is the NAACP Legal Defense Fund, they actually started and settled a federal case on the issue of there was a night shift development in New York, and the police, the NYPD, wanted to get their numbers up, and they were specifically, the LDEF looked at, they were specifically going to public housing developments like, oh, well, we'll get our stop and frisk numbers up here. You right there, we're going to stop you, and we're going to arrest you. Number up. You right there, we're going to stop you, because we're in such and such development. And so they brought litigation challenging the NYPD stop and frisk policy specifically on public housing grounds. So this is a real issue of people being harassed and unlawfully arrested on the basis of their race specific to public housing. So Helen's going to talk about what we were saying before about the hyperregulation of people of color, tying this in, and just the idea of the criminality of people of color.
Great. Can someone actually tell me how long we have until? I'm trying to think how much detail I should. 12:30. Okay, great. Well, yeah, I'll still try and make it brief. So one of the ideas that's been sort of underlying a lot of this conversation that came up during Natalie's presentation, I think you brought it up as well, is this stereotype that exists in the media, in the public image of the projects, of public housing. It's a very racialized image, right? People of color living in high-rises, they're poor, it's ravaged by drugs, it's ravaged by crime, right? And this is an idea that I think is really important to talk about because it underlies and is some of the assumptions that people are making when they're developing these sorts of policies. So I want to talk about, like, to what extent is that stereotype match the reality on the ground, and to what extent is that reflected in public housing? So as Natalie stated, when public housing was first built, it was actually housing for white working class folks, right? But by the time you get to the 80s and 90s, that's changed. So in 1991, 61% of public housing is people of color. 2001, 67% is Black and Latino. So it's correct to say that a majority of public housing residents at this point in time are people of color, but it's certainly not all public housing residents. And I think in the media, you would have an idea that it's like 99%, people of color, Black people, Latino, Puerto Rican, and it's 61%, right? So you're a little over half, right? But certainly not all that way. The other idea that exists around public housing is that all public housing is high crime, and that the structure, as we were talking about before, the structure breeds crime, and that public housing is rife with crime. So this is actually also not borne out by data. So what I want to point out is that during the time where these images were being projected and folks were saying crime is so bad in public housing, there was actually no national data that separated out crime in public housing residents versus crime in the rest of these cities. So the police departments didn't keep a separate file for public housing residents versus other folks. They had crime data for the whole city. So at this time where it was like a widely accepted fact, even one of the head researchers for HUD stated that valid statistics on the level of crime in public housing do not exist. That's in 1998, 2 years after, well, that's 10 years after the policy was signed into law and 2 years after it's become a national policy in terms of one strike. And that's not to say that there wasn't crime in public housing developments, but there's a lot more variation and there's a lot more complexity than you would be led to believe by the public perception and the media perception. There was a recent study by criminologist Fritz Umbach, and basically his conclusion was that, I'll just quote him, some public housing seems to have increased crime rates under certain conditions, while other projects under different conditions are actually safer than private housing. So there's a variety of different things that are going on here, clearly in different public housing developments, but we had a very stringent, very draconian policy applied nationwide to all public housing in every single city and county in the country. And I think the other elements that the media perception and the stereotype fails to capture are the causes, right? What are some of the root causes that led to high crime in some public housing developments? Because we know that there was increased crime in some public housing developments. Well, I think a lot of scholars have concluded that it's a lot of the same factors that led to crime in many other areas of the country. High structural unemployment, deindustrialization, jobs moving out of cities. Unemployment is actually one of the factors that has the highest correlation to likelihood to commit a crime, right? So in these cities, as jobs are moving out of the city, as we're losing industrial jobs, a lot of folks, higher number of folks may be unemployed. I think another important thing to think about is redlining and white flight. So, how is it that it got to be that we had larger numbers of people of color living in public housing? Well, you know what? Maybe they weren't able to rent an apartment on the private market because of redlining. Maybe they weren't able to purchase a home because the home wasn't offered to them. So a lot of these factors, which are, racism, historical segregation, and racism, are, what leads public housing to start to be more and more people of color, because it may be one of the options that's actually available to them at the time, right? And there's also a little bit of a chicken and the egg thing, I think, here when we talk about the decreased federal funding. So the federal government started drastically pulling back on their funding for the housing developments at the same time that more and more low-income tenants are moving into these developments. This is the time where you would actually need increased federal funding, right? So then once federal funding's decreased, you see, oh, the properties aren't maintained. Oh, they're dangerous. Oh, there's all their conditions. There's all this crime. Well, so people will say, oh, this means that public housing doesn't work. Well, does it mean that public housing doesn't work, or does it mean that we didn't fund public housing, so we set it up to fail, in essence? So I think it's important to think about that relationship, because the funding for public housing was cut prior to a lot of these critiques. So it's just interesting to think about. I also want to, I know we've, between the two presentations, maybe given you a somewhat grim picture of public housing, because these are issues that we feel very passionately about, and they're huge issues, but
And we're on the ground, so we sort of
we see, and we also, you know, all the folks coming to us are having, a lot of folks coming to us are having these issues, but just to give you a little, I don't know, a little bit of the other side. So, I mean, public housing is the single largest source of affordable housing, for instance, in New York City today. 600,000 people live in public housing in New York City. That's bigger than a lot of large cities in the U.S. I imagine it might be bigger than Raleigh and Durham. I don't know the population of those cities, but it's a tremendous amount of people that are living in permanently affordable housing. And it's really incredible, because you have folks who are living in the Upper West Side, in the Lower East Side, in areas of the city that otherwise people would be completely priced out of at this point because of the rates of gentrification in New York City. And they've been able to stay in their homes and stay in their communities, right? So that's a huge success. And public housing, I think there's also this idea that Natalie talked about, that public housing residents needed to take more personal responsibility, right? That's really what this policy suggests. You know, it's that, you know, we're going to take this individual action against individual tenants because they need to take responsibility for their homes, responsibility for their guests, responsibility for everything that happens. And that, to me, undercuts actually the organizing of public housing residents that have been going on for decades, right? So it wasn't like, you know, in cities or in neighborhoods where public housing did see an increase of crime, like residents were just sitting around. In New York City, you actually had some really active organizing by tenant leaders and tenant activists calling on the city to give more funding to maintain the development, to give them more resources, to keep crime down in their developments. And unfortunately, so they actually pressured the New York City Housing Authority to set up a task force to examine these issues. Unfortunately, the sort of solutions that were handed down were these very personal responsibility solutions. I think their message and their efforts were kind of co-opted into, oh, well, we're going to take time to evict folks. So, okay, what? If they have any questions, yeah. I just want to say one more thing. I didn't get a chance to go into like how this fits into a larger pattern of criminalization of people of color, but just suffice it to say that over the course of our history, from the Constitution, the Fugitive Slave Act, if you're a person of color and you run away, you are a criminal, right? So you're basically a criminal for being a free person of color. This is something that is embedded throughout our history, from before the Constitution to lynchings, which were actually justified by saying, oh, like black people, you know, are committing all these terrible crimes, and that's why these lynchings are justified. It's used as a justification for lynching. And the war on drugs, started by President Nixon, while at that point it wasn't explicitly acceptable to say who it was against, it's very clear from the outcome who the war on drugs was really targeted towards, right? And I want to read one quote from one activist to close. So this is from Connie Burden, who was a public housing activist in Tampa. And she was evicted because her son had been arrested on drug possession. And this is how she analyzed the situation. Okay. I make no apologies, Ms. Burton said, but because of the rules of public housing, we are forced to abandon people who find themselves in a crisis. People reached out to Governor Jeb Bush of Florida when his daughter Noelle had problems with drugs, but they didn't get evicted, right? And you want to talk, another example is we had a President Bush, whose daughters were in rehab, having drug issues, and arguably in the most expensive subsidized housing in the country. in the White House, but didn't really see any consequences. But I mean, just to sort of issue like the double standard, right? And as I said before, there's no such standard for other forms of subsidized housing, such as home ownership and mortgage interest deductions. And so that's just a way to end.
With a boom.
And that is, you've given the worst case scenarios here. I mean, like, which I understand, that's what we're trying to say. But are there instances where whoever's in charge is a little bit more sympathetic and, you know, their kids got into trouble and they say, well, we'll give you another chance? Or do they just become so hardened? I mean, I know you got to have some percentage of each one, but it just strikes me as curious.
So that's where, so let's say the situation is a person, again, I'm the tenant of record, and I live in a household with Helen. And Helen is accused of engaging in criminal activity, and we're all faced with eviction. Then a lot of times people do the hearing, and a lot of times the end result, the curing part, is just permanent exclusion. Because again, when we're talking about, here our article is about just general criminal activity, but specific to drug-related criminal activity, everyone can be evicted. And so the policy I was talking about before, permanent exclusion, is seen as sort of a middle ground or last resort, and that's generally seen as the curing aspect. But in terms of particularly of, well, you've been arrested of this crime, I haven't seen in practice public housing authority just saying, because a lot of times, you know, they literally will rely on the arrest record. I haven't seen where they say, well, let's wait, except for the case I mentioned, let's wait until the end of this. What I have seen is they'll say, okay, we'll put you on probation. We'll give you what's called a probationary stipulation, where you still get to live here, and for 1 year or 2 years, you're on probation. And if you breach any rules, like if you're late with your rent, or if you get arrested again, or you engage any kind of conduct that is a breach of the rules, then you're definitely getting evicted. So, you know, that in practice, for me representing tenants, tends not to be the best solution either, because again, you know, the overarching issue is, like, a lot of people might not have committed these crimes. Like, we have to wait until the resolution of the criminal case. But then in addition to that, you know, I've been late with my rent. It's like, I don't know, 1 month. If you give a 2-year period, there's been a day that I've been like 2 days late. But in these scenarios of a probationary stip, it's like, that's it, you're late 2 days, we don't care, now you've definitely got to go. So if it's, like, a lot of the probationary periods are not specific to the conduct that originally got you on probation. Like, for example, if you've been arrested for robbery and your case is still going on, and then the probationary stip doesn't necessarily say you're on probation, and if you get arrested for robbery one more time, we're going to kick you out. It typically says if you breach any rules, if you don't pay the rent, if you do this, if you look cross-eyed at the housing manager, like, for crying out loud, like, you're going to get evicted. So, you know, we think it's our position that the best result is, again, to wait for the resolution of the criminal case, but we haven't seen in practice anyone doing that. And you know, from the housing authority's viewpoint, again, we've heard about the incentives. You know, from the housing authority's viewpoint, it's not a lot of incentive to keep tenants anyway. There's a lot of backdrop. Again, we began with this of why public housing even exists, right? And so if people are getting evicted, there's not necessarily a cry, knockdown fight like, no, we have to keep people. It's like, all right, well, you've got to go. That's it.
From a funding perspective, would you expect increased evidentiary standards to increase administrative law hearing costs? And then B, if so, do those costs come out of general housing and urban development funds, or how are increased court costs or administrative hearing costs paid for?
So I think one element of our proposal, which is that they wait for the disposition of the actual case, which I think would be a best case scenario. The disposition of the case in criminal court is even better than having a raised evidentiary standard that happens before the conviction. I think that is actually maybe the most cost-effective solution because the criminal justice system is set up to do just that. So if you wait for the criminal justice system to make a decision, then you don't have to hold like another substantive hearing with a higher evidentiary standard. But if, as an alternative, we have this proposal about a higher evidentiary standard.
But even if you did, the end result would be that the housing authority would have to show a conviction, would have to show that the person definitely engaged in the crime. And what that would result in was, okay, well, there's the arrest record, but where's proof that the person has been convicted? So in terms of the housing authority, they already have attorneys. So it doesn't mean that they have to hire more attorneys for an elevated evidentiary standard. In terms of, from their standpoint, it doesn't mean that they have to, per se, have more witnesses. It literally just means that they have to prove that the person has actually engaged in the conduct, and what that results in for them is perhaps more paperwork, like here's the proof that the person has been convicted. It could be more witnesses, but it doesn't substantially change like the amount of money that they would have to spend.
And they may initiate fewer cases, right? If they know that they have a higher burden to meet, right? Like if they just have an arrest record and nothing else, then that's not a case worth pursuing, perhaps. I think it also, our point is that that these measures were put out there in the name of tenant safety, right? And so really, NYCHA, the housing authority, shouldn't be playing a purely punitive role. Only in cases where we know that there's a real threat to safety should they be taking these sort of actions. So we think that much fewer of these actions should be taken because a lot of the cases that were being initiated now and initiated across the country, it's not clear that what's being done is going to improve tenant safety in any way. And the criminal justice system already exists as a punitive system. We don't need people's homes to become another punitive system as well.
Now, is this something, you mentioned NYCHA is run by the federal government. Is this something that could be addressed through executive order, or does it need a legislative solution? Does it need a new bill to be passed?
So there have been some, realistically, I don't think that, let's put it this way. We have at the local level HUD contacts. So HUD is the overarching federal agency, and then they have local contacts in, let's say, New York or whatever. And honestly, just from a practitioner standpoint, you call and you say, this is what's going on. They're pretty hands-off. So in terms of like practically how it plays out in terms of HUD's role, I don't know about other housing authorities in the nation, and it might have something to do with NYCHA being seen as some sort of success story. But in terms of practically how the overarching role of HUD can affect like whether NYCHA can do its job or not, I haven't seen that actually happen. So I think that in terms of for obviously our reform and our relief would be changing the actual policies, like legislative changing the actual 2 federal regulations so that it wouldn't have to be that you could just go ahead and start eviction proceedings against someone with such low proof. So that's what answered your question?
Yeah, and one positive thing that has happened, I talked before about how housing authorities were being graded really strictly on the number of these evictions they were carrying out. That's been rolled back. So they no longer have to report really high numbers of these evictions in order to maintain federal funding. So these evictions are authorized under federal law, right? And to make them illegal, we would need new legislation. But housing authorities now are in a position where they're not being pressured by HUD to pursue these, so they have the ability and the discretion to roll back some of these policies within different housing authorities throughout the country, and that's what we're pushing on New York to do.
Well, thank you again, Helen and Leah.